Okay, good evening, everybody. My name is Ida Ashuri, and I am a staff attorney with the Legal Aid Foundation of Los Angeles. And this is a Know Your Rights webinar presented by the LA Small Business Legal Aid Program. So firstly, this presentation is only for informational purposes. It is considered simply general guidance. It is not legal advice. And we highly recommend, if you have any specific legal questions in accordance with your business, to contact us directly, and the information will be at the end of this webinar. Please keep any questions that you do ask general during this webinar. So first, we are going to ask a question from you. What brings you here today? Are you here to ask about your commercial lease? Do you have a general question about your business? Is your business currently facing a legal issue? Do you want to learn how to form a business? Or is there another reason? And feel free to share that in the chat. Okay, thank you. So a little bit about our program. We are a partnership with the City of Los Angeles, as well as other nonprofits. And our goal is to provide free legal assistance to small businesses, as well as connecting small businesses to other attorneys that can help. A sample of different things we do are provide webinars and presentations, provide direct clinic representation or client representation, and provide a small business legal academy. We do have that plan for December 7th, so feel free to register on our website. It's from 4 to 7 p.m. and it will be in person at our office, the Ron Olson's Justice Center, which is near MacArthur Park. Our nonprofit can help with issues such as drafting and reviewing contracts, advice on forming your entity, drafting and reviewing leases, intellectual property, negotiating rental debt, issues specific to childcare providers, and issues related to your website. And another question, we'd like to know, how did you hear about us? Was it through social media? Was it through LAFLO's website? Was it through the LA Legal Help website, or another way? Great, thank you. So today we're going to talk about the LA tenants protections for commercial tenants, general commercial lease issues and protections, commercial rent debt, and conclude with opportunity to ask questions. So firstly, we're going to discuss the commercial tenant protections. Commercial tenants with less than 499 employees were covered under these protections. The protected period is March 4th, 2020 to January 31st, 2022. There was a repayment period up until January 31st, 2023 of this year. One thing to note is that these protections still exist. So what that means is that your landlord cannot evict you for rent that is accrued during that time, but they can sue you for that rent in a civil court. But again, it can't be used as a reason for eviction. At the same time, the landlord cannot add any interest or fees to that rent accrued during that specific time. But again, you can still be sued in civil court. But again, you are still protected regarding unpaid rent during that period. So another question, where do you conduct your business? Do you lease a commercial space? Is it done out of your own home? Is it online only? Your location changes, maybe swap meets or farmers markets. Other, feel free to share in the chat. So now we're going to talk about commercial leases. Some important terms to know for commercial leases: the type of lease that you have, assignment and subletting, default and remedies, personal guarantee, repairs and maintenance, insurance, and the ADA or the Americans for Disabilities Act. So types of leases. The different types of leases are gross, modified gross, and triple net. Under a gross lease, the tenant pays an agreed upon flat rent, and the landlord is responsible for the costs associated with owning the property. In a modified gross or base year lease, the landlord is responsible for the cost of owning the property during the initial part of the lease term, usually the first year, and then the tenant only pays a portion of the amount by which these costs over time exceed the base year costs. As over time these costs increase, the responsibility for the tenant increases as well. Under a net lease, not only does the tenant pay the agreed upon fixed amount of rent, but the tenant also pays for some of the costs associated with owning the property. This can be ranging from taxes to insurance and maintenance. When all three of these things are included, it's called a triple net lease, or NNN. Each N is referencing one of those categories, so taxes, insurance, and maintenance. An assignment and subletting. The tenant has a right to possession or interest in the property, but that right can be transferred to a subtenant, which is less than the whole interest in the property, or it can be an actual assignment, which is a transfer of the tenant's entire interest in the property. You're going to want to examine the lease and determine whether or not you can even do that, because some leases prevent you from subletting or assigning the lease. One thing to note, that with a subtenant, they pay the rent to you as the tenant, and then you pay the rent to the landlord. If the subtenant breaches the sublease, the tenant can repossess the portion of the property that was subleased. An assignment, the tenant transfers to someone else or an entity the entire interest in the property. So you also want to determine whether or not that is okay with in the lease. In the case of a sublease, the tenant is liable for all of its obligations in the lease, because you're not transferring those obligations to the subtenant. Like, for instance, the rent, which you have to pay directly to the landlord. You would also still be liable for any other obligations under the lease. If And also if the assignee breaches the lease, for instance, if they put a sign up that's not allowed, the original tenant, you would be liable. Default and remedies. A default is when you are breaking the lease or doing something not allowed in the lease. These are the different categories or hypotheticals for when that happens. A landlord can default or break the lease by failing to maintain the property or violating the lease obligations. There are some requirements, obviously, for the landlord in the lease. That's another reason why it's very important to read your lease, because that lease will tell you what you're responsible for and what the landlord is responsible for. And then the lease should also state what the remedy would be or for the breach, or if there's an opportunity to fix the default. So here the tenant may sue for breach of contract or seek damages for constructive eviction. So if a landlord is not living up to their obligations, that could be considered what's called a constructive eviction, and you can try to escape the lease that way. Regarding the tenant, a few examples of default are failure to pay rent, failure to maintain the property, or failure to maintain sufficient insurance. The remedies could be that the landlord uses a security deposit to supplement the rent, or the landlord may terminate the lease and sue for damages. One thing that's really important to know is if your lease is broken because of something that you did as a tenant, you may still be obligated to pay the remaining rent in the rest of the lease. So, for instance, if you break the lease for some reason, or you fail to maintain sufficient insurance, and you're only 2 months into a 2-year lease, you may be obligated to pay the remaining 22 months on that lease. So that's something to keep in mind when signing the lease as well. And usually when the lease is terminated, it can't be reinstated. So again, it's really important to keep that in mind when signing, and to make sure you read the lease so you know all your obligations. So for instance, to know whether or not you can obtain that insurance before you end up defaulting. It's possible a negotiation is to find another tenant to really release a property if that happens. But again, that's a case-by-case scenario. We don't recommend that commercial tenants withhold rent if a landlord is not keeping up with their obligations. You want to make sure it's legally settled, because you can still get evicted if you withhold rent. If, for instance, a landlord is not making required repairs or something like that. And just for your information, security deposits can only be used for necessary and reasonable uses, and not ordinary and reasonable wear and tear. Personal guarantee, sometimes there's a additional document attached to the lease called a personal guarantee, and that makes whoever signs it liable for rent or liable if the lease is breached. So if you sign that in your personal capacity, which means your individual name, your personal assets would be open to be sued upon. So for instance, if you own a house, then your personal assets, your home, can be used to pay off the lease if they plan on suing you in civil court. Versus if you sign as a legal entity like a LLC or an incorporation, then your personal assets are not at stake. This is a way that the landlord tries to protect itself from tenant default to get a third party to make them liable for the lease. So it is beneficial to enter into the guarantee or the lease as a legal entity and not as an individual to protect your personal assets. But to inform you, if you do end up getting into legal proceedings, you are required to be represented by an attorney, because once you are a LLC or a incorporation, you're no longer a person, you're an entity. So you can't represent yourself because you're not an attorney. You would need to hire an attorney to represent the entity. So if you do end up, getting into eviction proceedings or something else, that's something also to be aware of. Repairs and maintenance, it's very important to check the lease for who is responsible. There might be some things that landlord is responsible, and there might be some things that you as a tenant is responsible. You want to check the lease for that. You also want to check the lease to see who is responsible for the common areas, or what's called CAM, C-A-M. For commercial leases, you are not allowed to deduct repairs out of the rent. That's also something that's usually listed in the lease. So unfortunately, if that ends up being the situation, you would have to pursue that those reimbursements through civil court, maybe, or small claims court. Usually the landlord is obligated to maintain the common areas and the exterior of the building, like electrical, plumbing, the HVAC. And usually the maintenance of the interior is something up to the tenant to do, but that's not always the case. So again, you want to read your lease. In a typical multi-unit or multi-tenant building, the tenant may be obligated to pay some costs with respect to maintaining some of the common areas. So that's also something that could be in your lease. And you want to also look at how is that payment being calculated, because we have seen some tenants see a very high rise in those fees. And so you want to make sure to read that lease and see how those fees are being calculated. Usually it's calculated in terms of share by dividing the square footage of the entire property between the tenants. But you also want to see how the camp fees are, for instance, maybe charged each year if they accrue, if there's some kind of calculation or system that they use. You also could request a right to terminate the lease or request to reduce a rent if the landlord is not living up to their obligations to do repairs. But again, you want to check the lease to see if it's their obligation. And you want to, or it's highly recommended to inspect the premises or hire a contractor if you're able to see if there's any repairs you may be later responsible for. Insurance. Again, you want to check the lease and see the amount and type of coverage required. A lease is generally going to require some kind of insurance for liability for personal injury and damage to the tenant's property. Some, but not all leases might require the landlord to maintain insurance. You want to talk to an insurance broker to see if the coverage is available in the amount required and the type of coverage in the lease. Maintaining insurance is really important because failing to do so can be a breach of the lease. And most commercial leases state that the landlord can't be held liable for damage to the tenant or to the tenant's property. even if the damage is the result of the landlord's negligence. They require the tenant rely on their own insurance. So think about the scenario of a pipe bursting. That might have been the landlord's responsibility, but they don't have any responsibility for reimbursing you for damage to all your furniture in your unit. So that's something to be aware of. The ADA, this is a very important thing, and we can often see this with small businesses. You want to inspect your lease to make sure that it's ADA compliant, and you want to see who is responsible for ADA compliance. We work with small business owners that have been sued for ADA compliance issues, such as lack of ADA parking, lack of a bathroom that is ADA accessible, not low enough counters, doorways, or aisles for people with disabilities. An ADA violation can be very expensive and time consuming. So a tenant should start at the outset to negotiate a lease to see if the landlord responsible for making sure the premise is ADA compliant, and to have a landlord responsible for ongoing ADA compliance. Under California law, every landlord is required to advise a tenant whether the property has been inspected by a certified access specialist, CASP, CASP. And if so, the landlord is required to provide the tenant with the report generated as a result of that inspection. A CASP is a professional that's been certified by the state of California to have the knowledge required to adequately assess a property's compliance with state and federal construction related accessibility standards, including the ADA. So again, you want to be aware of your rights, which are to know whether or not the property is ADA compliant and whether or not it's been inspected, and also who's responsible for ADA compliance. These are all requirements of California law in a lease. And you want to negotiate to have the landlord be responsible. You may still be responsible for things inside, for instance, inside the unit, because the landlord can't control, for instance, where you put your furniture to make sure the aisles are wide enough. So you want to be aware of that. These lawsuits are very costly. So again, having your lease in your personal name, if you are sued by the ADA, your personal assets could be seized for this lawsuit. Commercial rent debt. We know many tenants have incurred significant amounts of commercial rent debt due to the pandemic. There are some rent relief programs and grants, but we highly recommend negotiating with your landlord directly. Some places like the city of LA County have in the past helped commercial tenants by giving them grants to pay their debt. Currently, they are not accepting applications, but they were some months ago. You want to, if you're giving your landlord any money for previous rent, you want to make sure that you speak to an attorney first before you sign anything, and also to get an agreement in writing to make sure that they don't sue you for any back rent and that your back rent is forgiven. Don't hand over the money without a settlement agreement. We can help you get waivers of back rent in exchange for providing some kind of chunk of money and protection against a landlord from them suing you in the future. So again, we will provide the contact information at the end, but feel free to contact us to help you with that regard. You can try to look for private charities, the City of LA Business Project, or the LA County Department of Economic Opportunity to see if there's any rent assistance, but we highly recommend you negotiate. When you are negotiating, you want to have some things in mind, and these are strategies that we've seen work, whether it's commercial rent debt or high rent increases. And you, as we're talking through these, try to also think about the landlord's perspective too when negotiating. One option is to negotiate a repayment plan. If the repayment plan would allow you to preserve your tenancy and that's what you want, consider that. Don't agree to a repayment plan that you cannot afford to comply with. Think about what you can offer and what you will ask for, and negotiate based on what you can realistically pay. Some options are a lump sum towards the back rent in exchange for waiving the remaining balance. Another option is asking for lower monthly payments if you were impacted by COVID. Another option is just to ask if you can break the lease early because you cannot pay the rent anymore. You might want to help find another person to take over the lease. You want to know you and your landlord's BATNA, best alternative to negotiated agreement. For your landlord, will they get more money if they sue you? If they want to go through that process, are you what's called judgment proof, as in you don't have any assets for anyone to collect on, like we had talked about, like a house or something. Do they have another tenant who can take over the space that's already lying in wait? For tenants, is bankruptcy an option or going to court? Communication is essential in these situations. You want to communicate early, often, and most importantly, in writing. You should save all your communications with the landlord and property manager. That includes text messages. That is also considered in writing, or emails. You should send communications also according to the notice provisions in the lease. The lease will say how you're supposed to notify your landlord of information. So you want to look at that, and it's called notice provisions. In addition to email or phone communications, you want to see what's required of the lease, because the landlord could say, you didn't do it this way, so I don't have to acknowledge it. You should also notify the landlord of any relevant eviction protections, like we had discussed, and maintain any records, like issues with bills, healthcare bills, childcare bills, pay stubs, etc., to show a loss in income or an increase in expenses, to show if you had an issue with paying rent. And this could be helpful in your negotiations or even for applying for any grants to help pay rent. If you do negotiate a settlement, you make sure that it's in writing, and that if possible, it should include a full waiver of back rent or claims related to the lease. Don't sign an agreement until without consulting an attorney. We recommend you try to speak with an attorney, and again, we offer free legal services before you sign anything. So the same thing for rent increases. Know your BATNA, which is what's your best case scenario? What might it be for the landlord? Is it moving out and finding a cheaper place? Is that possible? For the landlord, is it letting you stay at a smaller increase of rent because they might have a hard time finding someone else to rent the space? Is the landlord even able to rent the space to someone else at the higher rent? And have you made any improvements to the property that has saved the money? These are all things to consider when negotiating with the landlord for rent increases. You again want to assess your exposure, like we had discussed before. You want to see if you have signed your lease as a corporate entity or in your individual capacity, and whether or not you've signed a personal guarantee. This is important to think about when considering how a landlord might want to recover the back rent. If you sign your lease in personal capacity, they could go after your personal assets. So you would be more exposed in a lawsuit. Just an overview on negotiations. You want to request, if you can, a gross lease, which was the lease that has just a flat rent. You want to insist on a cap on expenses. If you're required to pay them, so that's like a limit. You want to try to have an audit provision on the lease. Basically, if the landlord is, requesting you to pay for different costs, you should be able to look at the landlord's financial books and records to see where are these charges coming from and if they're valid. And you want to make sure the property is zoned properly. This is something, it's kind of like a buyer beware thing. A property might be sold to you for a barber shop, but it might be zoned for a medical supply or medical building, which means you won't be able to technically legally operate as a barber shop. And so you might be responsible to change things structurally to the building to make it compliant if you aren't aware of these zoning issues. But it's better just to find a place that's zoned properly. Insist on a fixed price and a lease extension. So usually there's an option on a lease to extend it for 5 years once the initial lease expires. You want to make sure that the lease says that the new extension is operating at a fixed price. In California, it's illegal to say that the lease would go to fair market rent, but you still want to make sure that the lease doesn't state that. Again, you also want to be aware that you cannot deduct any of the repairs or maintenance you might conduct from the rent. So there might be something in the lease that allows you to do that, but it's rare, and you want to again read your lease to see if that is possible. So overview on negotiation tips. Review your lease. I think we said that a lot, but it's really important. And before you sign it, review it, assess the tenant's obligations, the landlord's obligations, what happens in case of a default, and whether or not it's been signed in the individual name, and if a personal guarantee was provided. Consider all relevant details, which are the length of the tenancy, how much the tenant has spent improving this premises, whether the space can be leased to another tenant easily, whether the tenant wants to stay at the space or move out. Know the law if there are any commercial tenant protections that could help you. Know the market. How much is the market rate rent for the space? Are there other tenants that want to lease the space? And know the agreement. If the landlord and tenant are entering into some type of agreement, settlement agreement, what does it say? What are the terms? And importantly, what happens if the terms aren't followed? This is a website for reviewing the tenant protections, though again, they're expired, but in the sense that there's no more protections, but still at the same time, you're protected for that specific period. But that period is over now, so you can be evicted for any rent you didn't pay after that date, but not for that unpaid rent during the year prior. And then we have also a guide to commercial leases as well you can access. So now is the time for questions if you have any. If you do request any further assistance, and we highly recommend contacting us at 866-375-9511 or going to lalegalhelp.org, lalegalhelp.org. The website is translated into the same languages we have today, which are Spanish, Korean, Mandarin, and Vietnamese, as well as English. So feel free to go to the website if you need any assistance. If you have any questions, feel free to put them in the Q&A or chat or raise your hand. We do have webinars regarding how to form an entity or entity choice, and they are on our website, which I also recommend going to at Laughless website, which hopefully someone can put in the chat. And we have also another webinar about contracts. So these are already recorded, and they have been presented in multiple languages. And we have PowerPoints for those presentations as well. And you can look at those at our website as well. Okay, well, it looks like we don't have any questions. So if there's no other questions, just want to say thank you so much for attending, and we are going to conclude this webinar. Feel free to follow us on social media. Thank you so much for attending. Have a good evening, everybody.